They are using this motion right now to try to get cameras banned from the courtroom for, and this is just my understanding, for any of the pre-trial hearings, not the trial itself, just the pre-trial hearings, so that they can prevent any more potential problems that would taint the jury pool. Imagine if they had put out more damning evidence against Tyler Robinson to the public. I firmly believe that they would be motioning to have this dismissed. What is the FBI hiding, guys? Why are they hiding all this evidence? Why are they not showing the public what really happened? Why aren't they telling us? Let's go ahead and take a look at this motion that was filed by Tyler Robinson's defense. And maybe you'll start to understand why they aren't just dumping all of this shit on us, why they're not telling us all of the evidence they have, why they're not proving to all of you. Argument 1. Mr. Robinson's concerns about prejudicial pretrial publicity are not merely hypothesized. Mr. Robinson's concern about the effect of prejudicial pretrial publicity in this extraordinary case is not merely hypothesized. The problem is an ancient one. Mr. Justice Holmes stated no more than a commonplace when 2 generations ago, he noted that any judge who has sat with juries knows that in spite of forms, they are extremely likely to be impregnated by the environing atmosphere. Nowhere is this statement more true than where television cameras have been allowed into the courtroom at the pretrial stages of a criminal case, or where television news crews are turned loose on those eager to obtain fame or fortune concerning a pending criminal case. And then here they cite a United States Supreme Court case. From the moment the trial judge announces that a case will be televised, it becomes a cause célèbre, which I think just means like tracks a lot of attention. The whole community, including prospective jurors, becomes interested in all the morbid details surrounding it. The approaching trial immediately assumes an important status in the public press, and the accused is highly publicized along with the offense with which he is charged. Every juror carries with him into the jury box these solemn facts, and thus increases the change of prejudice that is present in every criminal case. And we must remember that realistically, it is only the notorious trial which will be broadcast. The conscious or unconscious effect that this may have on the juror's judgment cannot be evaluated, but experience indicates that it is not only possible, but highly probable that it will have a direct bearing on his vote as to guilt or innocence. In this case, Mr. Robinson appeared for his first court appearance without the benefit of counsel on September 16th, 2025, on WebEx from the Utah County Jail for a full 12 minutes, wearing what appeared to be a bulletproof vest or suicide vest. The media broadcast the entire hearing and thus exposed countless numbers of prospective jurors to the image of him sitting in jail, clothed in prison garb. They also heard the court ask whether the jail was ready, and heard the court pronounce that Mr. Robinson was being held without bail because he was being charged with a capital offense. Moreover, since the date of this appearance, clips from that video or another showing close-ups of his booking photograph displaying the same clothing, which were released by the sheriff, have been broadcast thousands of times with subsequent stories about this case. Even before Mr. Robinson's first court appearance, politicians, federal and state law enforcement officers, and the lead prosecution attorney in this case publicly offered their opinions about Mr. Robinson, the details of the investigation, including an alleged confession, and even specific items of evidence and forensic tests that have not yet been deemed admissible at trial. For instance, 2 days after the shooting and shortly after Mr. Robinson's arrest, President Donald J. Trump appeared on a nationwide television broadcast and announced with a high degree of certainty, "We have him," and stated, "I hope he is going to be found guilty, and I hope he gets the death penalty."
What's going to happen to this guy?
Well, I hope he's going to be found guilty, I would imagine, and I hope he gets the death penalty.
On the same date, the governor of Utah began his video press conference dramatically with the words, "We got him."
Good morning, ladies and gentlemen. We got him.
He and FBI Director Kash Patel then spent 24 minutes detailing all the alleged evidence against Mr. Robinson, including the allegation that he had confessed and the content of incriminating messages allegedly connected to Mr. Robinson. At the end, the governor returned to the microphone and announced that there is one person responsible for what happened here, and that person is now in custody and will be charged soon and will be held accountable. On September 15th, 2025, Mr. Patel appeared on national television and announced that the DNA hits from the towel that was wrapped around the firearm, the screwdriver, are positively processed for the suspect in custody.
And I can report today that the DNA hits from the towel that was wrapped around the firearm and the DNA on the screwdriver are positively processed for the suspect in custody.
Also on September 15th, 2025, U.S. Attorney General Pam Bondi appeared on Fox News side by side with a blow-up of Mr. Robinson's mugshot in prison garb and announced that the governor has said that they want to seek the death penalty, which is very real in Utah, and they still have the firing squad in Utah, and that as federal prosecutors, we will look to see if we have federal charges as well. And of course, if we do, we will also indict and work hand in hand with the state to ensure that this horrible human being faces the maximum extent of the law. Let's jump down to argument 5 here. Mr. Robinson agrees with the sheriff that this court should limit video and photographic coverage of court proceedings so that his physical appearance is no longer the subject of interest and his right to a fair trial by an impartial jury is fully protected. For reasons outlined in point 1, and because of the extraordinary nature of this capital case and the need to ensure a fair and impartial jury that may ultimately decide whether he lives or dies, Mr. Robinson agrees with the sheriff that the court should limit media coverage or video and photographic coverage at the least, so defendant's physical appearance is no longer the subject of interest and he has some chance of securing a fair and impartial jury. The United States Supreme Court has stated that while the First and Sixth Amendments guarantee the right of the press to attend a trial and report on what they have observed, the 14th Amendment due process clause assures each defendant the fundamental right to a fair trial. Federal courts have universally found that restrictions on videotaping and cameras do not implicate the First Amendment guarantee of public access. The Utah Supreme Court has stated that the media has a right of access to criminal proceedings, but this right is not absolute and is subject to exceptions. The court thus has ample authority to restrict the media in this case and should prohibit any further still camera, photography, or video coverage of any proceedings to safeguard the due process rights of the accused and to discharge its affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity. Based upon the foregoing, the court should order relief consistent with Mr. Robinson's motion. I don't know how much more of this I need to read, but I think you guys get the point of where I'm going with this. They are using this motion right now to try to get cameras banned from the courtroom for, and this is just my understanding, for any of the pre-trial hearings, not the trial itself, just the pre-trial hearings, so that they can prevent any more potential problems that would taint the jury pool, which would include more pictures of Tyler Robinson in, some type of jail clothes or jail outfit. Anything else that would make him look guilty before they can select a jury. This is a motion to just get cameras banned. If they had dumped more evidence, there's a fucking solid chance that we would see a motion to have this case completely thrown out because it went against his constitutional right to have a fair trial with an impartial jury of his peers. Do you guys understand that now? This is a motion filed by his defense. I'm going to go ahead and link this. If you guys want to read this, feel free to read through this. It's only, I think, 25 pages. It's not a lot, but it should give you at least an understanding as to why they can't just put all of this evidence out and show that he is absolutely guilty before a trial happens. And this is for all of the conspiracy theorists out there, okay? You don't get to say they're hiding shit anymore. You just don't, because I just showed you why they can't release all of that shit. They are legitimately using what the feds and the Utah authorities have already done as an excuse to try to get cameras pulled. And this is just from pre-trial court hearings, not actual trial. Imagine if they had put out more damning evidence against Tyler Robinson to the public. I firmly believe that they would be motioning to have this dismissed. Wouldn't surprise me at all. Not saying that the judge would grant that. I don't know how he could not do it. I feel like they would definitely have a really good constitutional argument there. I would love to hear a take from a criminal attorney. And I really hope that all the people that are on X right now that are going through every little fine detail and every little video and image to try to judge if somebody's reaction to the situation is suspicious or not. I really hope that you guys put at least half of the effort that you're putting into that into learning about how our criminal justice system works a little bit and trying to at least comprehend and understand what's going on. A little bit, just a little. You don't have to put, it doesn't take much. 25-page document. I think as long as you have decent reading skills and reading comprehension, you will be able to understand why the FBI and why the Utah authorities can't just give us all this evidence to prove that our conspiracy theories are wrong. Well, I have a conspiracy theory, so now the feds need to prove me wrong. Forget about how our criminal justice system works. Forget about all that. You need to prove to me, Joe Blow citizen, you need to prove to me, because I don't trust you guys. Our trust, we don't have any faith in our current government. You need to prove to me. And by proving to me, I don't care that you're absolutely risking letting off the potential shooter, letting him just go free because you violated his constitutionally protected rights. Don't care. Prove to me. All right, I think I made my point. We'll catch you in the next one, guys.